Hi, Tony DeWitt here, Missouri appellate attorney, retired, a guy who likes to make the law make sense. And today, it's one of those videos that everybody loves, lawyers behaving badly. So let's jump right into it. Today is a lawyers behaving badly story, but in order to get to the lawyers behaving badly story, I have to tell you a little bit of a whodunit that to this point has not been solved. So with that introduction, let's dive right in. There are certain truisms that apply to most homicide cases. In most of these cases, the victim knows the person responsible. In most cases, the perpetrator is inside a close inner circle, either family or friends. When the victim is married, the most likely suspect and the one always investigated first is the other spouse. Whether the victim is married, whether it's male or female, whoever the surviving spouse is becomes a suspect almost immediately. This is experiential learning. Cops know that these things happen, and that's the most likely course of action. So that's the way they tend to investigate. These truisms, or what we might call presumptions, tend to influence the way a case is investigated and usually solved. But just as with all presumptions, sometimes the evidence gets in the way. Susan Morphew was a Colorado mom who was believed to have gone on a Mother's Day bike ride back in 2020, and she simply vanished out of clean air on that bike ride. Her bike and helmet were found near the $1.75 million Mayville, Colorado home that she shared with her husband Barry and their children. An extensive search found nothing. During the investigation of the disappearance, the state developed evidence they believed pointed to Barry, her husband, as the reason she was nowhere to be found. Her husband had offered a $200,000 reward and gone on TV tearfully asking for her return. He cooperated with the police, but the evidence started to pile up. In May of 2021, prosecutors charged Barry with his wife's disappearance and presumptive murder because she had not been found. In preliminary hearings, prosecutors revealed that Suzanne Morphew's 2-year affair with another man, and they submitted evidence including scratches on Barry Morphew's arms and a tranquilizer dart and needle that had been found at the Morphew home. As to the tranquilizer, Barry told investigators he used tranquilizer darts to immobilize deer and cut off their antlers. Ugh, poor deer. Can you imagine chomping on grass and then waking up with the mother of all headaches and finding somebody had stolen your hat? In April of 2022, prosecutors dropped the case, and it was dismissed without prejudice, which means that the state could refile it at some point in time in the future. But even if they recharge Barry, there's a really great chance that he'll get off, or more importantly, that he didn't do it in the first place. Male DNA was found in Suzanne's car. The partial DNA profile created from DNA left on Suzanne Morphew's glove box matched profiles developed in sexual assault cases in Phoenix and Tempe, Arizona, and Chicago. That information came from the Colorado Bureau of Investigation. Barry fought back tears at the preliminary hearing when the FBI agent testified at that hearing. The agent confronted him with Suzanne's affair, and his answer to that was, "That doesn't mean I didn't love her." Is it really possible, even probable, that Barry really did love his wife? Barry knew that his wife was estranged from him, even though she remained in the home. It would appear that although there was formal notification of the affair when he sat down with the cops, that he might have been vaguely aware that something was going on, even if he didn't know who. But certainly Suzanne knew. In March 7th, 2020 message to an old flame, a guy by the name of Jeff Libler, Suzanne wrote, "Nobody loves you like the way I do. I crave time with you. I crave the feeling I get when we connect, physically or emotionally. You're my guy, always." And in another text message, she said, "You're the only real love I've known, the only love I want." Investigators found a text that she sent to Barry that said, "Oh, I'm sure your mistress has you all happy now, so you can say you love me, but you bully me when you're with me. Yeah, that's love." 3 days before she disappeared, she texted him, "I'm done. I could care less what you're up to, and I have been for years. We need to figure this out civilly." because they did have children. So it's clear that Suzanne and Barry were on the outs and they were headed down that long slide to a divorce, or falling apart as a married couple. But does that mean Barry did not love his wife? Well, I've known a lot of people who've gone through divorce situations where the other spouse just picked up and walked out, and they still loved that person with all their heart. And they really had a hard time with it. They were nearly inconsolable. So it is possible, it may not be likely, but it is possible that he really did love his wife and was flummoxed by the fact that she'd disappeared. And while it could certainly be evidence of a motive to have her killed, there was never any physical evidence connecting Barry to the death. Barry was so upset that he filed a lawsuit against the sheriff and the district attorney. That's not yet been resolved. In October 2022, after the case was dismissed because of some pretrial rulings that went against the state, the prosecutors involved were under investigation for allegedly withholding evidence in the case. As you know, if you are a regular listener here, the Brady Rule essentially requires them to turn over potentially exculpatory evidence. Now, I'm not sure what the potentially exculpatory evidence was that they were trying to withhold, but could it have been those DNA profiles? There were also allegations of a plot against a judge. Now, what do we always say on this channel about judges? The number one rule of trial is don't honk off the judge. And just to bring this full circle, the next thing that happened after the dismissal, or I should say after the bar started to investigate, is that in September of 2023, outside the small town of Moffat, Colorado, in Saugatuck County, Colorado, Ms. Morphew's remains were found, and an autopsy was conducted, and they did find tranquilizers in her system. So, again, there are things that lead back to Barry Morphew, but no prosecution has been recommenced at this point. The DA, Linda Stanley, was reported to bar disciplinary authorities, but not so much for what her underlings did, but for what she did. Now, the Morphew case was high profile. It drew national media attention. It was a whodunit, and those kinds of cases tend to bring in tabloid media as well as the newest version of tabloid media, the true crime podcaster. Now, the initial disappearance was 2020, and they didn't discover the body until 2023, and so that was a period of time where there was a lot of things that were not known. But nonetheless, the state still indicted Mr. Morphew and took him to trial. Well, there are rules in every state that govern out-of-court statements by lawyers in cases in which they are involved. Colorado's rule, in relevant part, says this: a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Notwithstanding that, they can make certain statements, the claim or defense involved, information contained in the public record, that an investigation is in progress, the scheduling or result of any step in the litigation, a request for assistance in obtaining evidence, a warning of danger concerning the behavior of a person involved when there's reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest, and in a criminal case, in addition to those, 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the capture, the time, place, and date of arrest, the identity of investigating and arresting officers. Notwithstanding paragraph A, Rule 3.8F, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. And no lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. Comment 5, which is not a part of the rule, but which is meant to guide the application of the rule, tells what information is generally not. There are, on the other hand, certain subjects that are more likely than not to have a material prejudicial effect on a proceeding, particularly when they refer to a civil matter triable to a jury, a criminal matter, or any other proceeding that could result in incarceration. These subjects relate to 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness or the expected testimony of a party or witness. In a criminal case or proceeding that could result in incarceration, the possibility of a plea of guilty to the offense, the existence of the contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement, and that will be important in this case, and the performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of a physical evidence expected to be presented. 4. Any opinion as to the guilt or innocence of a defendant or a suspect in a criminal case or a proceeding that could result in incarceration. 5. Information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Or 6. The fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. In addition to all of the foregoing, there were a lot of problems in the Morphew case. There were issues with discovery that was not timely provided to the defense. There are certain timelines and standards where this information has to be turned over. The judge issued a scheduling order and the prosecution had trouble keeping up with it. In that particular county, they didn't have a large staff, they didn't have a large budget, and this was Linda Stanley as the DA. It was her first supervisory assignment as a lawyer. She'd been a hearing officer for one of the Colorado departments at some point, but she had never supervised a large office, and she did not have felony trial experience. She'd never tried or defended a felony case. In an effort to make some of this make a little bit more sense, I'm going to go through a little bit of the timeline here. On 5/6 of 2020, Suzanne texted her husband and said, "We're done," as I mentioned earlier. And then on 5/9, that's the last time anybody saw her. On 5/10, she goes riding. And on 5/11, that is the last contact with Morphew, in that her boyfriend gets a text from her. Now, of course, he got a text from her phone, not necessarily from her. On 5/13, after she'd been missing for a day, they found her bike helmet and her bike a few miles away from her home. And then from July 9th through the 10th of 2020, the sheriff's officers descended on the home, tore it apart, looked for any evidence that Barry Morphew might be involved. And they found no blood in the home, but they did find a tranquilizer dart and basically a gun capable of shooting that tranquilizer dart. So the investigation proceeded apace, and then in May 5th of 2021, almost a year to the date after she went missing, they indicted Barry Morphew for first-degree murder and tampering with evidence. Then, and this isn't really important in the disciplinary case, but as far as the status of the case, the remains were found last September in 2023. And of course, no prosecution or no additional prosecution has been mounted in that case, although it could be because of the fact that the first prosecution was dismissed without prejudice. So now this is the timeline from the investigation of the bar. In other words, it lists all of the things that sort of contributed to the discipline. Well, maybe not all of them, but the vital ones. So we'd start with the indictment in 2021, and at the time that he was indicted, Ms. Stanley went before the press and said that he had been taken into custody, and when asked questions, said he wanted a lawyer. Well, every prosecutor knows that you absolutely cannot comment on a person's failure to speak because they have an absolute privilege, Fifth Amendment, not to speak, or their request for a lawyer. Those are forbidden. Every lawyer knows that. Every prosecutor knows that. Why she made that statement, I think you can attribute it to inexperience. She'd never prosecuted a felony case at this point. So on 5/17/2021 through February 14th of 2022, the state's discovery responses were untimely. And on May 15th of 2021, she dished dirt to a YouTuber saying basically things about the case that she knew she shouldn't say. And of course, he relayed that to the people who were watching his podcast. On June 3rd, because every defense counsel will monitor the media about their client, the defense asked for a gag order and they asked for a motion to compel this late discovery. The judge granted the motion to compel and he ordered Stanley to stop doing pretrial publicity. Well, but in mid-June, she again dished more dirt to the YouTuber. She said, "We got him, no worries." Well, that conveys the idea that he's going to be convicted, which again is an assumption of guilt, and you cannot do that because you haven't proved a darn thing at this point. So again, that was an ethical violation. From August and September of 2021, she appeared on the Profiling Evil podcast, contrary to the June 3rd order. And in late September, she responds to comments on that podcast. Remarks that she made in that response were just over the top. And by the way, the order is available on the internet if you care to go looking for it. It's an 80-page order, and I'm not going to read the whole thing. We're just going to look at a couple of paragraphs out of it. On August 30th, 2021, she appeared on another podcast, and in response to the question, "Is Barry getting ready to flee?" she said that possibly he was. She claimed that was a neutral comment, but of course, as we've said on here before, the guilty flee, the righteous are as bold as lions. When you suggest that someone's going to flee, it suggests maybe they're guilty of something, and again, as a prosecutor, that could materially prejudice his right to a fair trial. From August of 21 through April of 22, the subordinate prosecutors, missed deadlines, engaged in a plot against the judge, and wound up with the case being dismissed. And then in April of 2022, that same time frame, on April 15th, Stanley ordered her investigator to go interview the judge's ex-wife, with an idea of perhaps getting leverage, I suppose. So in October 30th of 2023, the Colorado disciplinary authorities charged her with 7 counts of misconduct. And this is the actual order, the opinion imposing sanctions, and it talks about how after the disappearance of Suzanne Morphew, there was a case that was filed that as a result, the respondent did not adequately supervise the prosecution of the case, and she made 3 extrajudicial statements about the case to the media, which threatened to prejudice and undermine the public's interest in justice. Those statements contributed in large part to a judicial ruling changing venue in the case. And of course, whenever you change venue, it increases the costs to the state to make the prosecution. After the presiding judge issued adverse rulings less than 2 months before jury selection, respondent instructed her chief investigator to interview the judge's former spouse to determine whether the judge committed domestic abuse, even though she had no credible evidence to believe that the judge had ever engaged in that kind of criminal conduct. Respondent ordered the investigation in order to uncover information about the judge that would require him to recuse. Shortly after the interview, which revealed the judge had never abused his spouse, the respondent dismissed the case without prejudice. In a bid to rehabilitate her relationship with the media, she later agreed to sit for a videotape interview. During that interview, she made extrajudicial statements about 2 defendants criminally charged in the death of a 10-month-old infant. She effectively pronounced one of the defendants guilty, revealed inadmissible details about the defendant's juvenile offenses, impugned the motives and character of the defendants, and 2 judicial officers ruling independently concluded that her extrajudicial statements amounted to outrageous government conduct so severely prejudicing the defendants that the judiciary was required to dismiss each defendant's criminal case. Taken in totality, a majority of the hearing board concludes that these ethical violations warrant respondents' disbarment. And using nautical terminology, this is how the professional discipline judge summarized the conclusion. In their opening statement, the people likened respondents' handling of the Morphew prosecution to that of a ship's captain who never appeared on the bridge. In some ways, this analogy is apt. Respondent's absence at the helm during key phases of the prosecution, even when she was warned that it faced rough waters, led to a series of events that ended with the first-degree murder case running aground. The analogy captures respondent's dereliction of her duty as an elected official and the top prosecutor in her district. In that role, her obligation was not to win or to protect her reputation, but to see justice done. Instead, her unjustifiable extrajudicial statements in the Jacobs and Crawford cases led to the opposite result, prejudicing each criminal defendant and torpedoing the criminal case against them. And her baseless decision to launch an in-house investigation of a judge presiding over a case that was close to trial prejudiced the administration of justice and abused her position of trust. She must be disbarred. Now, she has the opportunity to appeal this to the Colorado Supreme Court, and likely she will. The Colorado Supreme Court is the entity that makes the final judgment about whether a lawyer can continue to be a lawyer in Colorado. And they generally review those cases where somebody brings them a case to review, and that would probably be what Linda Stanley chooses to do here. In that regard, they might be able to diminish the punishment, take it down to a suspension, for example. They might be able to find some technical violations with respect to due process. I don't know. It's possible they could reverse in whole or in part, but it's very unlikely that they would reverse in whole. And any reversal of any particular element is probably going to just mean that the only sanction that you get is suspension. Now, one problem for Stanley is that she does have a prior disciplinary case when she was in private practice for a very short time, and as a result, sort of as a recidivist, she's not going to get the breaks that somebody who, is new to the practice of law might get. And because she had 10 years of experience as a lawyer when this disciplinary hearing was taking place, she doesn't get, a lot of breaks for that either. What she should get breaks for, in my humble opinion, is that she just got in over her head. Now, she didn't do the right thing and wave the red flag and say, hey, help, help, I need some help here. She didn't immediately recognize this prosecution was too big for her and seek help from the Attorney General. Instead, she wanted to be somebody who, took in this big case and prevailed. And ego is always a problem. When ego gets in the way of a lawyer's objective analysis, it can be a problem. So I think this is a good finding by the disciplinary authorities out in Colorado, and we'll have to wait and see if she appeals it to the Colorado Supreme Court and what the outcome of that is. But I thought it was an interesting case because it was so tightly wrapped up in the Morphew case, and I've been looking at that for some time. I would really kind of wondered what had happened to the prosecution there, and of course when I did the follow-up on this case, I found out exactly what happened. So thank you very much for watching. I appreciate you being here. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that good stuff that everybody asks you to do. I'd certainly appreciate it too. In fact, if this is the first time you've seen us and you're interested in subscribing, boy, I'm down for that. If you have the opportunity today, go out of your way. Do something nice for someone. Just any little thing. And then, when you're done, come on back tomorrow. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. So please don't take anything I say here as legal advice, and if you need legal advice, see a lawyer in your jurisdiction. And keep in mind that if you don't have money for a lawyer, if there isn't a legal aid society that can help you, often law schools have clinics where student lawyers can represent you in court, and often they do an awesome job. And here are some videos that YouTube thinks you may enjoy.